Good evening. This is John Milburn for Laws 12062 Alternative Dispute Resolution. We're into week 10. I guess this week everyone wants some tips in relation to the take-home examination. The first thing that I can say is that I'm reliably informed, thank you Ainsley, that the take-home examinations from previous offerings of this unit are on Moodle. And I've been taking this unit for the last, 4 or 5 years, so they would have been written by me. They're quite different each year, and you can expect something different again, potentially this year. I suspect that if I was preparing for the take-home examination, I'd be very interested in what we're doing tonight. I'd be very interested in what we did last week, and I'd be interested in restorative justice mediation. They're probably the 3 areas where I'd concentrate. Now, when I say this week, it's likely that this week will spill over into next week as well. So whilst I'll introduce criminal justice system mediation tonight, I will expand on that later in a couple of weeks. Tonight we're talking primarily about statutory provisions for ADR and the concept of good faith negotiations, and that morphs into legal matters, legal and ethical issues involving mediation. So 3 main areas for the take-home exam. Number 1, those areas that deal with alternative methods of dispute resolution with an emphasis on dispute prevention. That's one area. The second area relates to the statutory ADR processes that we'll introduce tonight and probably next week. And the third area, justice mediation. If you have any questions about the take-home exam, please feel free to ask tonight or during our Zoom sessions, or as always to do so through UCrew. Just on UCrew, I've received advice it won't be extended beyond this term. So those of you that have worked in the past have used UCrew with me. Next term I'll have to learn a different procedure to fall in line with the other lecturers. Now, criminal justice mediation. Again, just a brief introduction. It is entirely possible and becoming increasingly more popular to deal with criminal law disputes by way of mediation. In 2014, there was the introduction of the Offender Mediation and Conferencing Program through Victoria. It has expanded into Queensland. It's all quite new, of course, but it follows on from information mediation type work involving children, which was an earlier offering. So adult criminal justice mediation is quite new, but very effective. So I undertake mediations, and for example, what will happen is that either defence or prosecution would contact someone like me, advise that there is a person who's currently before the courts, charged with a certain offence, and the alleged perpetrator and the victim of the alleged crime both wish to undertake restorative justice as a means of resolving the issue. And typically, if the mediation proceeds before the mediator, it will be in confidence, other than by advising prosecution, if they choose not to be directly involved in the mediation process, with advice as to whether the mediation resulted in a settlement to everyone's satisfaction. And the advantage for the defendant is that rather than being processed through the criminal justice system, having a criminal conviction potentially, and being punished as in a criminal charge, the prosecution typically will offer no evidence. So they will not have anything on their criminal history. That's a huge advantage for a defendant. The advantage for the complainant victim is that in those circumstances where there's uncertainty about the outcome, fear and apprehension about having to give evidence, uncertainty as to whether there would be any real compensation or restitution provided to them, and fear that they're losing control of this process where they're the victim, they can feel empowered and have some real say in the outcome by involving themselves in criminal justice mediation. Of course, it's a process that needs to be undertaken carefully, sensitively, and with the needs and requirements of the victim primarily in mind. It is a process that I think should be victim driven, so that the victims feel that they have a suitable outcome. Whilst justice mediation can be undertaken in a wide range of areas, I guess it's fair to say that it would mostly be suited for crimes that involve monetary issues such as fraud, stealing, possibly break and enters, or crimes that involve people in a particular relationship. So if it was an assault matter, that can certainly be the subject of criminal justice mediation, but it might work best if it was, say, two brothers who got into a fight during a night of drinking, and they want it resolved between themselves rather than necessarily going through the court process. So we'll talk more about that later, but please do start to read about restorative justice in the criminal justice system. Start to read about justice mediation in its various forms, adult, children, drug matters are three examples of how diversions and mediations can be used in that criminal justice space. Are there any questions briefly on restorative justice, justice mediations, criminal law mediations before I move on?
Yeah, hi John, it's Nicholas.
Yes,
Do you
Nicholas.
have any specific text you'd recommend we read in regards to those areas?
No, it's very new. I do hope that I've put some material on Moodle, but I will check that. Seeing I've flagged it as one of the three areas, I'd better ensure you have some proper resources. Has anyone come across any
Yeah,
resources?
there is some in the book that we've got to read, but it's very minimal. It's only like half a page, and there's no real references to any other material. So that's why I asked.
Okay, I'll make sure that I put something there or check what's there to give you a fair chance. All right, thank you very much for that, Nicholas. Any other questions? All right, we will revisit that. So this tonight was for at least that part, just a brief introduction. Just a reminder, we're now into feedback mode. You'll notice the big red button. It's very important for the university and for me that we receive your feedback. Please let me know through UCrew or email if you have any concerns or problems. We're keen to know about the unit that we offer, that I've been offering, about the assessment regime, the Zoom lectures, any of those sorts of things. So if there's any concerns, please particularly let me know. Now, court-based mediation. There are a wide range of processes used across different jurisdictions. Tonight we'll be talking primarily about Commonwealth matters initially, and then we'll move to state-based matters. In the Commonwealth sphere, we're really talking about a couple of key pieces of legislation, some regulations. We'll refer to Nad Rec and a report that was prepared in 2009. We'll talk about some of the Federal Dispute Resolution regulations and the bill and the act that followed from that bill. In the state jurisdiction, we'll be talking from a Queensland perspective about the Civil Proceedings Act 2011. We'll talk about the UCPR, the Uniform Civil Procedure Rules, and we'll talk about some hybrid techniques in relation to, say, QCAT dispute resolution. Some of the procedures that we'll talk about tonight are compulsory. Indeed, many of them are, but it's always open to have voluntary processes run in conjunction with the mandatory requirements. Now, in about 2009, when Nad Rec produced its report in relation to the whole concept of mandatory ADR becoming mainstream, built into the legislation, it's fair to say it was controversial. Many of the lawyers involved in litigation didn't like it. Many of the people that were, if you like, victim-based organisations or support groups didn't like it because they felt that in those circumstances where there is a real or perceived power imbalance, the victims would be forced into a situation which was very uncomfortable for them. I think it's fair to say that now that we're implementing these procedures, they are becoming more accepted, and I think the benefits of the mandatory regime are becoming apparent. The reality of the fact is that most litigation is resolved before we go to trial. 95% at least, I would think. Many disputes typically were resolved on the doorstep or the week before the hearing. So part of the philosophy of legislative introduced ADR procedures, particularly at a very early stage, are to accelerate that process. Why go through that, all the cost, all the time, if indeed as a result of mandatory ADR, even before filing, we can force the issue of the parties engaging in a meaningful dialogue. That's the theory behind it. So increasingly in legislation, we're seeing a tendency to require this mandatory ADR even before filing of material. And that's most apparent in the federal sphere. So that's why I'll be talking about Commonwealth legislation to start with. And we're talking about, from a federal perspective, procedures in the federal court, the family court, the federal circuit court, the Administrative Appeals Tribunal, and Fair Work Australia. So can anyone tell me the primary legislation relevant to dispute resolution in the Commonwealth sphere and the legislation that promotes, if you like, and mandates this requirement for mandatory ADR before filing? What's the cornerstone legislation? All right, I've caught you napping. Yes, B.
Civil Dispute Resolution Act.
That's it, 2011. So that's the cornerstone piece of legislation for the Commonwealth sphere, and it's the Civil Dispute Resolution Act 2011. I'd like you to read that legislation and do look at the regulations that flow from it and look at the Civil Dispute Resolution Bill. Now, I'm just going to share the screen for a moment, and hopefully this works, to give you access to a resource that I may not have put on Moodle, but I think is pretty useful. And it comes from, if you like, the statutory interpretation type work that we do. For those of you who may not be aware, I do a fair bit of work in statutory interpretation here at the university as well. You'll see that I've got, if I've got the page correct, an extract from the Parliament of Australia, the subheading Parliamentary Business. Please tell me if I haven't got that on the screen. And it should say Civil Dispute Resolution Bill 2010. You'll see below it, Bills Digest number 23, 2010-11. What we have there is the parliamentary material, the digest that was prepared for the debate. It doesn't have any legal status. However, it was at the time and remains a valuable resource, giving some indication as to the purpose, the background, the issues that led to the passing of the bill. So this is part of the expert material provided for the Parliament to consider in relation to the legislation. Now, it doesn't take very long in scanning down through that material before we see a reference to background, Nad Rec's report. So I'd urge you, as part of your background reading, to look at Nad Rec's report. It is, if you like, the cornerstone of this legislation that has become the cornerstone of ADR statutory procedures at a Commonwealth level. So have a look at the Nad Rec report. Now, I'm going to share another screen so that I can show you what this report looks like. If you don't have it, please find it. It shouldn't be hard to find, or I may have put links on Moodle. So the report that you'll see there in the digest material is the Nad Rec report, the resolve to resolve embracing ADR to improve access to justice in the federal jurisdiction, published September 2009. So that's referred to in the digest. Let's have a look at the actual report. To do that, I need to share the screen. Now, I suspect those of you that are very competent users of Zoom will know that there's a way to move from one screen to the other without having come back to camera. I haven't learned that yet, so that's why you see me momentarily before we dive off to another screen. Hopefully now you can see the screen that has Nad Rec and the report, the Resolve to Resolve, Embracing ADR to Improve Access to Justice in Federal Jurisdiction. Please tell me if that's not the report. So it's the report which was published in September 2009, referred to at an early stage in the digest, which led to the implementation of the bill, then the Act. So we're going back in time, but it's a valuable resource. This document is valuable for a number of reasons. The first is, when you read through it, you'll see that there's an executive summary. I'm just going to scan down. I hope this doesn't blur the screen too much. You'll see it's 196 pages. So there's a lot of material here. And if we scan down, you'll see that there is an executive summary. Always a useful mechanism, that with the table of contents where you've got a longer document. If we look at page 3 of the material, it says that a significant barrier, there it is, Chapter 4, a significant barrier to the use of ADR is the widespread lack of knowledge and understanding of ADR among the public at large, people involved in disputes and professionals. Many people in Australia do not know about or do not fully understand ADR. That may result in suspicion, confusion, unrealistic expectations, and/or dissatisfaction. So what that tells you is that as recently as 2009, not only the public, but professionals really didn't understand or even know about ADR. So we are, in this unit, studying material that's very new. However, that's the premise upon which this Act was built. And you'll see that there was talk about suspicion and confusion and dissatisfaction. If we pan down a little more, you'll see that Chapter 7 deals with better court processes using ADR techniques. And at pages 4 and 5 of the executive summary, it says that Chapter 7 deals with the way in which courts and tribunal processes could be enhanced to make them more time and cost effective. This is an important part. It discusses case management in federal courts, tribunals, including the recent decision in Aon Risk Services Australia Limited. The chapter contributes a range of techniques that courts already adapt from ADR processes, including family consultants, less adversarial trial, expert evidence management. But Nad Rec considers other ADR techniques might be appropriate for some civil proceedings, and they include case management conferencing. Then it goes on to make some recommendations. And at page 7 of the executive summary, you'll see the recommendations here. Specifically, encourage and implement the greater use of ADR processes used by federal courts and tribunals. And requirement, and this is the first time we see it, a requirement for genuine steps to be undertaken by prospective parties to resolve the dispute before court or tribunal proceedings are commenced, and that's at 2.1. All right, so what we have there is the background that led to this important legislation and this whole different change of thinking. What's also useful about that document that I've shown you is if you go to the final 2 pages, there is in attachment D a model ADR clause. It's useful precedent. It's relatively short. It's based on material from the Law Society of New South Wales website. Law Society of New South Wales have some great material. A lot of it's free, just as a plug for New South Wales Law Society. It's very good. And included, so in the last 2 pages of that 196-page document, you'll find a very good precedent about dispute resolution. That may be useful for your assessment. So, beyond that, the other important thing for you to consider is the Federal Court rules. So here's the Federal Court rules. That's what they look like. Quite a thick document. You can see that I've got that, and I've got the UCPR, which is the state-based rules, which is even much thicker, much longer, in hard copy, because they're a valuable resource in court. Now, so you'll need to consider that as well. But we'll just come back to the Civil Dispute Resolution Act. So we mentioned the digest. I've mentioned the explanatory note that went with it. Now let's have a look at the legislation. And if you look at, and I'll just ask you to follow this if you have access to legislation on your screen. If you look down through the legislation, you'll see that it's quite short, but very significantly is the reference to genuine steps to resolve a dispute. Have a look at sections 4, 5, 6, 7, 8, 9 in particular, and note the power of the court to have regard to genuine steps in the exercise of power and performance. A scary provision for practitioners in this very short but very powerful act is section 12, which talks about the power of a court to exercise a discretion when awarding costs in circumstances where, in short, if the court is not satisfied as to the attempt that was made by a party to take genuine steps to resolve a dispute, they may win, but they may not get their costs. Does that make sense? So when you're talking about these legal issues and the statutory requirements for ADR, these are the key pieces of Commonwealth legislation and resources that you need to consider. So the sections you want to look at there, 3, 6, 7, 8, 9, 11, 12, and then look at the powers of the court beyond that. Pretty much the whole bill, the whole act rather. So I mentioned the explanatory memoranda. Just bear in mind that when you're, and this is for this take-home exam, potentially this is a hint, but it's a hint that applies to all of your take-home exams. If you're referring to legislation in any assessment work, it's very useful to refer to the explanatory note or explanatory memorandum, as the case may be, because it demonstrates to the examiner a greater depth of understanding and research. And it's really easily found, that material, generally speaking. A bit hard to find pre-1999 material sometimes, but generally quite easy to find. And in this instance, if you look at the Civil Dispute Resolution Bill 2010 Commonwealth, you'll see that there is a good deal of material about what these specific steps mean, why it is flexible, why the arrangements in the Act are loose, and essentially to allow the parties to tailor the genuine steps to circumstances that best meet their needs, and why it includes obligations on lawyers and it has issues in relation to costs for non-compliance as a penalty against lawyers. So the bill provides background material that's very useful to you. Now, when it comes to this issue of genuine steps, I want to take you back to the Nad Rec Report that I showed you earlier, the Resolve to Resolve document, because in that it talks about genuine steps and it talks about why they chose that term other than different terms like good faith or genuine efforts. So genuine steps and good faith and other terms are defined in that documentation. So I won't go through that in any more detail, but to say that these are excellent resources that you should consider for the assessment purposes. All right, so that was the background to the Act. Now, in the Act, I mentioned Section 4 of the Section 4 deals with genuine steps. Section 4 talks about genuine steps in the Act, and that's the cornerstone. So if you're following the Act now, this is the Civil Dispute Resolution Act 2011, have a look at Section 4, which provides detail as to how these various discussions actually panned out in practice as the legislation. The only other thing I'll mention about the regulations is that there were some exclusions. So there were some discussions about what should be included or what should be excluded. For the most part, when it comes to Commonwealth legislation and disputes, everything is included, the requirement for the taking of genuine steps. But through the regulations, the Civil Dispute Resolution Regulations 2011, you'll see that there are some exclusions. For example, proceedings for sequestration orders under the Bankruptcy Act, or certain proceedings in relation to winding up of corporations are not proceedings where there is this requirement to undertake genuine steps. There's also reference to statutory demands under Section 459A of the Corporations Act to wind up a company in insolvency. So if you look at the explanatory statement to the regulations, that will explain to you why these things are not included. So you have the explanatory statement for the regulations as opposed to the explanatory note or explanatory memorandum for the legislation. Am I moving too quickly, or have you been able to follow? All good? All right. Now, are there any questions before I move on?
Yeah, John, can you just quickly mention each of those acts and or bills again, just in sequence, so we can get them all at once, please?
Good idea. All right. So I would start, and I'll sort of work backwards here. The Act at the Commonwealth level that we've been discussing is the Civil Dispute Resolution Act 2011, Commonwealth. Look at the Civil Dispute Resolution Bill, Commonwealth 2010. Have a look at the Nad Rec document. Then look at the Civil Dispute Resolution Bill's Digest document, which is through the Commonwealth Parliament. Bill's Digest 23/2010-11. And in that, you'll see a reference to the Nad Rec paper called The Resolve to Resolve Embracing ADR to Improve Access to Justice in Federal Jurisdiction from September 2009. Also look at the Civil Dispute Resolution Regulations 2011, Commonwealth, and look at the Federal Court Rules 2011. You should probably also look at the Federal Court of Australia Act 1975, and I'll get to that now. So that's just a brief summary of the resources that we've considered so far this evening. Did you catch all that, Nicholas? Was that all right? Yes,
Yes, sorry. You were saying how about the explanatory memorandum? You said the Civil Dispute Resolution Bill explanatory memorandum, which is actually different from the Bill's Digest. Is that the same thing?
No, I think it's a separate one.
Okay.
It's a separate one. I'll see if so it's the explanatory statement, thank you for that, B, to the regulations, which contains details as to why certain proceedings were not there. I've just called it up, and I will share the screen to show you the explanatory statement to the regulation.
How about the explanatory memorandum to the bill? That's yet another one?
Oh, yes, that is another one, but I haven't mentioned that tonight. But what I have mentioned here is the explanatory statement to the Civil Dispute Resolution Regulations 2011. And that's the explanatory statement based around the Civil Dispute Resolution Act 2011. Can you see that? All right. So lots of background reading to read, sorry. But don't go into it in too much depth. Just make sure that you're aware of it. You know, one advantage of a take-home exam, of course, is that it's not a memory test. So what I'm really asking you to do is have things lined up so that if the question that you have in the take-home paper is around this area, at least you've got everything lined up ready to look at.
Just a clarification,
Yes,
sorry, John, you mentioned the Civil Dispute Resolution Bill 2010, but when I go to look, it says Civil Dispute Resolution Bill 2011. And that's from the Parliament of Australia's Parliamentary Business website.
Let me share the screen, and I've got a feeling that there were two bills for this piece of legislation. I think it went through twice. But let me just share something on the screen, and I'll do that now. Are you seeing the Civil Dispute Resolution Bill 2010 from the Federal Register of Legislation?
Yeah, I've got that one. That one came through the House of Representatives on the 30th September 2010. It started, and then the Senate picked it up and moved it on the 23rd of March 2011.
Excellent work. Excellent work. I thought it was twice. Okay, so that'll give you two pieces of material to look at. Well picked up, Nicholas. How did you do that so quickly? You're just scanning everywhere. I'll give you the benefit and say you've done some homework before tonight's session. So thank you for that.
Sorry, I looked up the explanatory statement and it's only like 3 pages long. Is that the correct one? Yep. So it's mostly got to do, it looks like most of it's got to do with the excluded things. Like there's some in the textbook about the exclusion.
The explanatory statement is only short, and it deals with the exclusions of bankruptcy statutory demands. And I think there was a third one about eligible courts, but don't worry too much about that third exclusion. What would be useful is if we had a list of these things with links, wouldn't it? So perhaps one of us, it might be me, one of us might produce something. All right. Any questions before I move on? I mentioned briefly the Federal Court of Australia Act 1976. Thank you, Nicholas. www.aph.gov.au, parliamentary business, and then go through from there.
In fact, when you look at that, John, you'll see that it has both bills to look at. It has the text of the bill, all the explanatory memorandums, all the transcript of all speeches to do with it, all on one page.
Oh, okay. Very good. Nicholas, could I ask if you'd be kind enough to post that in UCrew?
Yeah, once the recording's done tonight, John, I'll go through and listen to it again, list them all and put up a document with all the links in there for you.
Thank you very much. That's very good. Oh, you've got a huge cheer. Thank you, Nicholas. That's great. All right, so let's have a look at some case management procedures. I want to now go to the Federal Court of Australia Act, and I haven't got this up on the screen yet, but if you could look at that Act, I want you to look at sections 37M and 37N of the Act, which provide for overarching purposes of civil practice and talk about the responsibilities for lawyers in ensuring that parties and lawyers think about the ways to resolve issues through ADR processes. there's reference to the Federal Circuit Court rules and the Family Law Act, and you'll recall from previous discussions the regime of a 60I certificate in relation to not proceeding in relation for parenting matters until there has been a genuine attempt through mediation. Right, so that's the Commonwealth regime. Let's move on to the state regime. Can anyone tell me the primary piece of legislation relevant to ADR processes in Queensland from a state perspective? Civil Proceedings Act, yes, 2011. So look at that act now, if you would. If you're watching this as a recorded session, just pause, make sure you have it up on the screen, and look at Part 6 of that Act, which commences at Section 37, goes through to 54, and it specifically deals with ADR processes. It deals with the interpretation, mediation, case appraisal, ADR processes generally, subpoenas, and protections, immunities, and confidentiality. So it does provide a great deal of substance to the process of ADR processes in state-based legislation. Supplement that, of course, with the Uniform Civil Procedure Rules 1999. I'm going to refer you to the specific rules that I think you need to consider in relation to ADR processes. So Rule 319 states that the registrar may give notice of proposed referral to ADR. Rule 323 deals with referral of a dispute to an approved mediator. Rule 324 provides for a period of conduct of mediation. 329 and 331 require a mediator to undertake certain work. 334 is a little different. It provides for referral of a dispute to an appointed case appraiser. 335 states that the case appraiser has the power of the court, and 343 states that a party dissatisfied with the case appraiser's decision may elect to have the decision go to trial. Now, while you're doing that, you're always mindful of where these things fit in the overall process. So what you'll notice is that case appraisal is not exactly referred to in the list of 14 matters mentioned in your text. Oh, the last rule was 343.
It is mentioned, case appraisal. Yes.
Which one is it? Which number is it, B?
Is it somewhere around 7? No. 8, 9, 10, 11, or somewhere.
Yeah.
It's more what they call an evaluative process.
It is, yeah.
It's an evaluative.
And that's what I mean. Just sometimes on the sliding scale, you don't have exactly the same words that are used, but it is more an evaluative process, which is, you're right, it's probably best somewhere between 9, 10 and 11. It's not quite a mini trial. It's not referencing out. So sometimes it's a bit confusing because when you're trying to cross-reference these terms, they're all still a bit new and there's an overlap, and sometimes we say different terms, or we use different terms for essentially the same thing. But I think you're right, B. Even though it's not specifically used by those words, it's in that area. Now, the Supreme Court announced that a resolution registrar had been appointed to conduct the pre-trial case management processes, and you'll see that QCAT and the Land Court of Australia also have embraced this through practice directions and in QCAT hybrid hearings. So I may have referred you in Moodle to some of these practice directions, but in the Land Court, you'll see that there's practice direction number 1 of 2015, which deals with procedures applicable to matters before the Land Court in relation to disputes for certain pieces of legislation. So I do environmental law as well at the university. So the Environmental Protection Act, Mineral Resources Act, these are what we call referred matters. So look at practice direction number 1 of 2015 in that regard. Look also at practice direction number 2 of 2015, which deals with dispute resolution processes relevant to land court proceedings on appeal under the Land Valuation Act. So litigants involve themselves in preliminary conferences and they relate to the valuation of land. So these are all, as you might expect, even though they're mandatory, they're legislation-based ADR processes, there's still the basic rules. Without prejudice, confidentiality still applies. And finally, look at the Planning and Environment Court, practice direction number 2 of 2014, which deals with case management procedures for the just and expeditious resolution of the real issues of proceedings at a minimum of cost. That's the same sort of wording that you'll see in the QCAT Act. All right, any questions on that material, which is really the week 8 material? I'm sorry, I'm a little behind. All good? Let's just make a start on legal.
I just have noted something in the Civil Proceedings Act under 46 subpoenas. In 46(1), it says a person may not be subpoenaed to attend a mediation, but then number 2, a person can be subpoenaed to attend a case appraisal. I just thought it was correct. a little.
Well, I guess philosophically, that reflects the fact that mediation is more of a voluntary process, typically speaking, and the case appraisal is more a determinative process. So it's a philosophical thing, and that kind of does fit in on that sliding scale that Spencer prepared on page 3 of the text. So, but it is an interesting differentiation. All right, so thank you. So legal issues. When we talk about legal issues, one of the key areas relates to confidentiality. Of course, confidentiality is a hallmark of dispute resolution procedures generally, and the reason that we encourage confidential discussions is that parties are more likely to be relaxed, comfortable, and open, which will hopefully result in a resolution, rather than being guarded, defensive, taking up positions, ignoring or not wishing to talk about interests and all those sorts of things. But there are some statutory exemptions to allow disclosure of confidential information. You'll recall when you did your ADR exercise that you probably spoke about some of these things. But can anyone tell me, and I've got 3 statutory exceptions in mind for disclosure of information. I will make it 4. Are there 4 exemptions to authorise disclosure of confidential information?
So probably imminent harm to someone, imminent harm to somebody.
Yep, threats, imminent harm. Yep, that's the first one I had down, but I've got 3 others in mind.
Is it if there's a legal requirement to do so, John? I can't remember what the phraseology is in regards to the legal requirement, but I know there was something about a legal requirement.
Yeah, I'm not sure that I can recall that. Monique is on the same line saying duty, so possibly. I didn't write that one down, but it might be open. Another one, so we'll keep that one in mind. Another one is to enforce an agreement. I think Amanda was on this track as well. So if you've got an agreement between the parties, then really I think that is something that can be disclosed, that goes outside the confidentiality. Maybe 2. Number 3 is this, to produce evidence to counter misleading the court. Now that's a grey area, but I've written it down as potentially an exemption to allow disclosure of confidential information. And number 4 is a little bit specialised. It's to do with costs. Does everyone know what a call to bank offer is? Right, so a call to bank offer is, without prejudice, save as to costs. So it's that disclosure that relates to the call to bank offer is something that can be disclosed without breaching confidentiality. Without prejudice privilege can be overridden in certain circumstances. Again, I've written down 5 here. Number 1, parties engaging in misleading or deceptive conduct. Number 2, through communication, the parties have created a contract. Number 3, the disclosure would prevent a court from being misled. Number 4, if the communication is criminal or tortious conduct. Or number 5, if the communication is not truly to do with settlement negotiations. The case there is Field against Commissioner for Railways. So you'll see that I've drawn a slight difference between disclosure of confidential information and disclosure of without prejudice privileged information. There's a huge overlap, but I think there's enough of a distinction to consider those as separate topics. Now, without prejudice privilege, a couple of basic things on this, and I'm very conscious of the time, so I'm moving fairly fast. Only applies to civil litigation. Well, that's theoretically correct, but in reality, we do have without prejudice discussions in criminal law matters, and we would expect that confidentiality to be retained and respected. So I disagree slightly with the author of our text in that regard. And justice mediation, of course, is a prime example of that, where we do have this mediation process in criminal proceedings. So take that part of the commentary with a little grain of salt, I think. Next, and we're talking about without prejudice privilege, only covers admissions, is not restricted to communication by lawyers, can be between the parties, refer to Rogers and Rogers, covers admissions made in reports produced by third parties, for example, experts, if it's to reach a settlement, and that's a thin area, but it's still there, and covers attempts to negotiate even before litigation has begun. Again, look at Rogers and Rogers. Now, I think this is referred to in your text. That decision is from 1964, 114 CLR 608. Prior to litigation, a separating couple entered into correspondence amongst themselves and through their respective lawyers. During the communications, the husband disclosed considerable detail regarding his financial position. Now, bear in mind, this was 1964. This is pre the Family Law Act. The High Court held that the family court should not have had access to that information in making an award in favour of the wife, because even though the parties had not headed the correspondence without prejudice, there had clearly been an attempt to resolve the matter by way of settlement before litigation, and that's why the disclosure should be regarded as confidential. That case provides a statement of the principle, but don't think for a moment that we would have the same outcome if the matter went to the court now. The principle is good, but the specifics in relation to the disclosure of documentation in a family law dispute has well and truly been overridden by legislation. Now there are some, yes.
Sorry,
Dave?
what about the one in arbitration? That's the one that seems out of place. The Esso and Plowman, it says that documents revealed during arbitration would not be subject to privilege unless it was demanded by the arbitrator, something like that.
I need to refresh my memory on that one, B. Sorry, so I won't go any further, but That's, yeah, I'd need to check on that one again, sorry. But thank you for that. All right, so just quickly then, exceptions to the operation of privilege. So the without prejudice privilege may not apply fully in some circumstances. Now, number one is if there's a waiver. Of course, people can waive the privilege, can't they? But only if the party waiving it holds the privilege. So when we talk, a good example there, I guess, would be legal privilege. The lawyer has no ability to waive the privilege, but the client does. So it's got to be the party that has the benefit of the privilege can waive it. Number two, to prevent a court from being misled. We're seeing a common theme there, aren't we? About the ability of a party to disclose what would otherwise be privileged or confidential or without prejudice material if it means that a court is not going to be misled. Philosophically, I guess we're looking at this paramount duty is to the administration of justice, which brings us back to issues to do with solicitors and barristers' conduct rules. So if you've got a question about this in the take-home exam, you really want to be bringing in commentary about conduct rules wherever you can and ethical requirements. Number three is to enforce a concluded agreement to ascertain what the parties had actually determined. Walker against Wiltshire is the case. And number four is the issue of costs, which is called a bank. So that's just expanding on what we mentioned a little earlier. Now the Commonwealth position, I don't have my Evidence Act here, but have a look at section 131, which provides in the Evidence Act Commonwealth the general rule about the exclusion of evidence of settlement negotiations. Evidence is not to be adduced of a communication made between parties in dispute regarding an attempt to negotiate a settlement or a document prepared regarding that attempt, and this does not apply if the party consents or tenders the document, or the substance was disclosed anyway, or it tends to contradict evidence, or to enforce an agreement, or to mislead the court, there it is again, or if it's relevant to costs, there it is again, or fraud or an abuse of power. So even though we've mentioned a few things tonight, maybe four or five, in the context of without prejudice and confidential information, have a look at the section 131, which goes a little further. Also look at privilege, and I think the legal professional privilege attaches to communications and documents, and the confidence remains with the clients in those circumstances. And
can I just ask a question for clarification? So, in all of the essence, any documents that are produced during a mediation, any discussions, and I think from what I was reading today, even email between the parties and so on and so forth, none of that can be used to further a trial in a court later on. But if during the process of mediation and at the conclusion of mediation, a contract or an agreement is made by the parties, and then one of those parties breaches that contract or agreement, is it not the case that the actual contract or agreement itself can be used in proceedings in the court action?
It can be, yes, I agree. So that is one of the exceptions to the general rule regarding confidentiality, to enable a party to enforce the agreement even though that agreement was struck in a confidential process. Absolutely, I agree. Does that help, Nicholas?
Yeah, that's brilliant. Thanks, John.
Oh, good. And while you were talking, see, look at me, I'm multitasking. I was listening to you, Nicholas, but also had a quick look at that SO Australia Resources and Ploughman decision that B mentioned earlier. And yes, you're right, B, that was the High Court was not prepared to imply a term of confidentiality in relation to information disclosed during arbitration. Does seem a bit odd. And again, it maybe just highlights the fact that although arbitration is as close as we have to court proceedings, it is still not court proceedings, but it's very close. So it's at that stage where it's removed from the main bulk of mediation type processes, and it's right there next to court proceedings, which are intended to be open to the public. So that's all I can think of as a justification for that position.
I think, John, if you keep reading in the textbook for this week, 2 or 3 cases after ESO, the judgment in the 3rd or 4th case, the judge in that essence dissented on what was said in ESO, and most other judges in cases from that point on have agreed with that dissentment. So ESO doesn't stand on its own anymore. It doesn't have the power it did.
And we're talking about ESO and Plowman?
Yeah.
Okay.
It's in this week's readings.
All right. Thank you very much. No, I'll need to refresh my knowledge on that. And thank you, Nicholas, for that. Look, we're just about ready to wrap up. Sorry, it's been a lengthy session again, but next week we'll kick off with some discussions about the Federal Court of Australia Act. Have a look at Section 53B. We'll revisit the Civil Proceedings Act, Section 36, and that's estate-based. And we'll talk about some more of the legal issues associated with ADR practice. All good? Any questions before we wrap up?
Yes,
Yes,
I think I got some conflicting cases about whether you can contract away your right to go to court, because they said all these clauses have to be in a Scott and Avery format so that you cannot exclude the jurisdiction of the court. But yet I think a few other cases said, no, the parties can contract away their right to go to court.
Yes. So, and again, we'll take up on that next week. But you're right. It all starts with Scott and Avery when we're talking about the enforceability of dispute resolution clauses. But you'll see that some of the cases take what I've described as a hard line approach. Elizabeth Bay Developments against Boral Building Services, for example, take that hard line approach. Ayton Australia against Transfield, likewise a hard line approach, as opposed to the more moderate approach in Computershare against Perpetual Registrars. So again, that's where we'll pick up next week. All right, all good? So we'll see you next week. Thank you for your attendance this evening. And any questions, please ask through UCrew and we'll go from there. Otherwise, we'll see you next week. Yes,
yeah, I've asked a few on UCrew about conference and conciliation. Like, I don't know what's a conference. They mentioned conference, but I don't know where is it on the scale.
Oh, okay.
Yeah, and the other one is conciliation seems more interventional than mediation, whereas it actually sits lower on the scale.
I know. I would actually swap them around. I would swap them around and put the conciliation at 7 and mediation on 6. That's what I would do. So I just agree with Spencer there. And conference is really number 1, negotiation. So it's very informal. That's the way I view a conference anyway. All right. Thank you for that. And we'll see you next week. All the best then. Bye.